she may be upgraded to the status of a general category candidate. Stop. If she seeks reservation, then another scheduled category candidate will miss the opportunity of reservation. Stop. The benefit of reservation is to be extended to a community as a whole and not to a particular individual. Stop. Prayer has been made to permit the commission to treat the petitioner as a general category candidate. Paragraph.
That is not my prayer.
Whether a reserved category candidate who disclosed the reservation in the application form can be treated as a general category candidate for not updating or editing the option allowed to the candidates has been decided by the court in WPA 26937 of 2025. Decided by the court on 27th November 25 in WPA such and such, Somnath Pramanik Amadir. Stop. The court was of the opinion that once the category of the candidate has been disclosed in the application form, the authority cannot suo motu change such category. Stop. By paying the fees meant for reserved category candidate, the authority cannot treat the said candidate to be a member of the general category for whom the application fee is higher than those of the reserved category. Stop. Paragraph. According to the Constitution, a candidate who is meant to be in a reserved category ought to receive all benefits of the said category. Stop. The candidate may, by her merit, his/her merit, be upgraded to the general category, but the same does not mean that she cannot avail the benefit of reservation. Stop. The reserved category, the community of the reserved category candidates consists of individual members. Stop. The community of reserved category cannot exist without the members of the reserved category. Stop. Since the petitioner has already declared herself to be a member of the scheduled caste category, she ought to be provided all benefit of reservation, including the benefit of counseling, which a reserved category candidate is liable to be provided. Step. Next. In view of the above, the instant writ petition stands disposed of by directing the commission to treat the candidature of the petitioner as a reserved category candidate in the scheduled caste category. Writ petition.
One line can be, one line can be subject to this. But he will not claim any benefit for the general category.
No, I am entitled for.
No. He will not claim any benefit for
the. She has recorded that I will only be treated as SC, both SC and general.
Yes.
That may be
all
recorded.
Facilities meant for a reserved category candidate will be available to you, which includes that if you prefer a general category seat, by virtue of your marks, you can get it.
Let that be recorded, my lord, since the contention of the commission, your lordship.
That is an absolute incorrect contention, and the court does not feel any requirement of dealing with each and every contention that is raised. Yes, please. Next.
I, my lord, for the petitioner, my lord.
Yes.
My lord, petitioner before your lordship is an untented teacher who is permitted to continue his service from 31st December 2025. My lord, this year, my lord, he also appeared. His subject, my lord, Persian PG, age 23. My lord, Persian PG, earlier occasion, my lord, appointment letter, Persian PG. And thereafter, lordship kindly straightway come to page, my lord, 32. Petitioner got out of 60, 56 number. At the bottom, my lord, written exam
Yes.
56. But unfortunately, that post is vanished. My lord, kindly come to page, my lord, 52. 52, my lord.
No, at the time of application, was any vacancy shown
Yes,
for Persian?
my lord, I permitted to appear in the written examination, but
Show me the vacancy list that has been published that Persian PG had a vacancy.
my lord, thereafter in tentative vacancy is not in the list, my lord, that post, my lord.
Then how did you apply if the post is not?
I am permitted to pay, but according to my lord, Honorable Supreme Court order, your lordship kindly have a look into 17th April 2024 order. 17th April order, already your lordship discussed so many times. There is specifically stated 17th April order and advertisement for press recruitment to the aforesaid post shall be published before 31st May 2025. Aforesaid post, and not only that, the main judgment. My lord,
No,
3rd
one
April
minute,
2025.
1 minute. This is a Supreme Court's order that you read,
My lord,
right?
before
Now the posts were declared by the commission.
post were declared by the commission. Now, my lord, post is
21st
not in the
31st of May 2025 was the date when the notification was published.
my lord.
Was there any vacancy shown in Persian PG?
My lord, that time, my lord, no vacancy.
Then why did you not?
Any subject. Thereafter, tentative vacancy.
When was the tentative vacancy list published?
June 13.
Very well.
Indicative vacancy list.
Right. Was Persian there?
No.
Why did you not approach the court?
My lord, I made a representation then and then tentative. That's why I permitted to appear in the written examination. And not only that, my lord, 3rd April order.
Show me your
29.
admit card.
Yes, my lord. 2025, page 31. Page 31.
Yes, page 32. I can see result of the written examination. Subject is Persian PG.
29, first, my lord. Application ID, male, Persian PG, 29. Medium of vacancy applying Urdu. Complete fees paid. And thereafter, my lord, was the PS 31. Yes, my lord, admit card, provisional admit card for second SLST, PS 31. Persian. Not only that, they cannot change, my lord, with due respect and submitting paragraph 49, my lord, of the main judgment, 3rd April judgment.
No, I followed. Please wait. Let me hear the commission. Commission.
That means Bandyopadhyay is there.
Regarding the Persian vacancy, the Persian vacancy. May I address your lordship? On the last occasion in SLST 2016, it was a school-wise vacancy position was maintained. But this time, it's a centrally the vacancy position has been maintained by the board. Now, if your lordship sees,
Is there any vacancy in Persian PG?
One. No, Persian Urdu. In Persian Urdu, there is only one vacancy. Therefore, if it is a centralized vacancy position is there, the 100-point roster is to be followed there. Now, kindly see the first point in the 100-point roster.
Yes.
The first point in the 100-point roster is a scheduled caste. Therefore, since there is only one vacancy, and it is first time from the school vacancy position, first time it is being done centrally, the first roster point is to be maintained. If there was two more, then there will be one unreserved and one EWS EC also. But since there is only one vacancy, the first roster point is being
No, doesn't matter. Then a scheduled category candidate will go in the Persian PG.
Scheduled category, the first roster point is scheduled caste. We'll have to maintain the roster point.
Maintain the roster point. This issue is with the subject. Persian is the subject.
Yes. But there is no malad, if at all no scheduled caste candidate is available, malad, this itself malad addresses that issue. That what is to be done in case malad the appropriate vacancy is not there, appropriate candidate is not found. But malad there cannot be any impediment that because there's a SC reserved, malad,
This is not an SC candidate.
no, malad, this post, it is a
Or
Persian Urdu medium. It is a Persian Urdu medium.
this is with regard to the subject. Is there any vacancy in the Persian subject?
Persian subject in Urdu medium, one vacancy is there.
There is.
Yes.
Have you advertised it?
Yes. It has been advertised, malad. And malad, it is, malad, it is, they have annexed it also. They have annexed it also. It is not quite legible.
Yeah.
The Lordship may take this, malad.
My lord.
They are not agreed by that. They say that why it will be SC reserved.
Not a word has been mentioned as to why it will not be SC reserved.
I have come malad reading the brief. The brief case is that why it will be SC, why it will not be unreserved.
He did not make any submission.
My
When he is making submission at the bar, I'm sorry to say this, malad.
My submission before your lordship.
Is that there is no Persian subject?
Persian, no
Vacancy.
Persian.
Yes.
That is scheduled caste. I am the jail caste.
So that
That is not his right. He cannot take out.
caste doesn't have any grievance.
No, he is saying, malad, his grievance in the writ petition is that there is only one vacancy and it is SC reserved. Therefore, you make another vacancy which is unreserved
That cannot be.
so that I can participate. But
No,
that is not his
no.
fundamental right.
That is. What is your case in the petition?
My submission before your lordship that the Persian subject vacancy not in the vacancy list.
Yes.
That is not only.
Have
that,
you made out this
not
case in the
only
writ petition?
Yes, madam. That is not only that.
Where have you mentioned?
SSC or state government cannot change the 100% roster. This time because it is a de novo process, de novo recruitment process.
You-
The order of the Honorable Supreme Court.
Show the according to the state there is one vacancy in Persian.
Yes, page 52.
He has
Yes,
annexed it.
see,
He has annexed it. I have
Then
given.
what is your case?
But my case is that the Persian general vacancy. But that is.
This is for the first time you uttered this word general.
Paragraph 18 is his case. Kindly see paragraph 18.
Please come.
52. That's it, kindly. Madam, they cannot.
Petitioner is a teacher of Persian.
But they cannot change the roster, my lord.
Malad,
The subject.
This is the
Urunima-
ongoing
Urunima-
process, my lord. With
Urunima-
due respect and committee, lordship kindly
Uh,
look into the order of the Honorable
the-
Supreme Court.
His allegation is that the
this point
that the commission
vacancy
did not
They permit.
disclose the vacancy in the subject
Old page
Persian
24.
in the advertisement floated for recruitment of assistant teachers in the year 2025. Stop paragraph. From the documents annexed to the writ petition, it appears that the commission has, not commission, the West Bengal Board of Secondary Education has already declared that there is one vacancy in subject Persian
But permit.
and the same is reserved for the scheduled category candidate. Scheduled caste category candidate. Stop.
The Urunima
The
judgment.
petitioner is a member of the general category. Stop. Submission is that one extra seat ought to be kept aside for the general category candidates. Stop paragraph. According to the state, comma, the 100-point roster has been followed and the first vacancy in the 100-point roster is reserved for the scheduled caste category. Stop. There is no further vacancy in subject Persian. Stop paragraph. The grievance of the petitioner for
Permitted me to. And they reduce the vacancy pursuant to the Honorable
Yes.
order of the Honorable Supreme Court, they cannot reduce the
That
vacancy.
point has been dealt with in Arunima Palmala. I can show.
All judgment has already gone pursuant to the order of the last order of the Honorable Supreme Court. Arunima Pal-
And the prayer of the petitioner for declaring fresh vacancy
Division bench
in
order.
Persian subject in the general category cannot be allowed by the court. The writ petition fails and is hereby dismissed.
No, let's say next matter is also same, but the subject is home science.
They allowed to sit in the examination and thereafter say,
Challenge the recruitment process. You cannot say you give me one more vacancy. That cannot be. You have to take a proper approach. Same thing.
Same thing, but the subject is home science postgraduate.
PG.
Home science.
Home
PG.
science also you do not have a
Home science
vacancy.
also one vacancy,
Only one
and therefore the
vacancy.
first roster point of SC has been applied.
Home science করে দেবেন। আচ্ছা ঠিক আছে next seven yes
Here, Lordship may kindly takes up, I'm challenging the list of 3,512 allegedly to be আমার বুঝতে হবে।
Niket. Yellow.
Allegedly,
petitioners are there
400
but
and
400 something petitioners. Our names have been included.
495.
Our names have been included
86.
in the list.
85.
Our contention before a lordship is that
how many court fees have you paid
my lord,
court fees
I will give the deficit force. If it is not paid, I'll replace.
your names are there in the list of tainted
Yes,
candidates
3,512 candidates.
Hmm.
Now, firstly, kindly takes up volume 1.
Volume
Show
one means
who are
after-
volume 1 of the papers. Yes.
yes
Page 100 onwards. These are our OMR sheets. Lordship would see these are all filled up OMR sheets. These are not blank OMR sheets. Now, my lord, that is our standing before a lordship that we are not within that category. Now, kindly takes up the my lord judgment passed by the Honorable Supreme Court. No. But I have not annexed it. I think lordship is having one copy, or lordship kindly keeps this copy. This is my lord Boishaki Bhattacharya, my lord. Kindly, it's easier to handle, my lord. Kindly comes first to internal page 9.
Mate
300 363 is the my lord paragraph which was quoted. First, second, third paragraph has been placed extensively before your lordship. Kindly takes fourth. Persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointment must return all remunerations and benefits received by them to the state exchequer along with the interest calculated at 12% per annum from the date of receipt thereof till disposal within a period of. So these are the categories who have been directed to be refund their salaries. My contention is that these are the tainted categories because that has been interpreted subsequently by a division bench of our honorable court. Because in this order, in this judgment passed by the Honorable Supreme Court, lordship has, the Honorable Court has in paragraph 45 upheld the decisions. Kindly comes to paragraph 45 straight away to the concluding part, or my lord, may I just first place paragraph 29 and thereafter so that it is chronology is maintained. Paragraph page paragraph 25, page 29 has been placed yesterday. This is the submission of the commission which has been recorded and set out. In the written submission, paragraph 25, that is page 29, internal page. This is in the written submission filed on behalf of the SSC in this court. Two tables have been furnished. Table 1 pertains to candidates who either jumped rank or were appointed despite not being in the panel. Their details as under. We are not these persons. Rank jumped, out of panel but still appointed. There is a common category there. Persons who were out of panel but were still appointed had rank jumped. So therefore the figure comes to 381 in group C. I am concerned about group C and group D. And the other figure is 608. It comes to 989. Lordship has directed publication yesterday of these persons. Now next table. Number of candidates with alleged OMR score mismatch as per CBI image. Group C, we fall in this. 3481. Group D, 2823. Now there is a next panel, next malord column. Number of candidates out of B who were appointed. So therefore all these persons in respect of whom OMR mismatch was found was not appointed. Kindly see the figure is less. It is 782, 1911, 2693 is the total figure. Your Lordship yesterday has directed publication of 7293. 7293 is the figure if the column A is added up. 3481 plus 2823 is equal to 6304 plus 989. So yesterday, that is why I was making submissions. Yesterday, your Lordships has been pleased to direct the OMR sheets of persons who have not even been appointed. My contention is that would also include, this is not my clients, but I wanted to draw your Lordship attention because it's our duty to point out things before a Lordship. So therefore, 7293 would be including persons who have not been appointed. Now, my lord, my contention here is 782 plus 1911, 2693. Now, my lord, kindly comes to paragraph 45, the conclusions. That is at page 39. The last question, which relates to the relief and whether it is required in modification, we find no valid ground. Page 39. We find no valid ground or reason to interfere with the direction. Here, the Honorable Supreme Court has upheld direction that the service of the tainted teachers were appointed must be terminated. They should be required to refund the salaries. So while saying so, the Honorable Supreme Court is referring to paragraph 630, 360. No, 630. 360. Yes, sorry. Now, my lord, kindly takes up the judgment. And here, my lord, now kindly takes up the judgment. Now kindly takes up volume 2.
From all this submission, what is the point that you are
Point
trying to
is
make
volume
up?
2. Volume 2, 2 paragraphs. Paragraph 31, 32 of the judgment passed by the Honorable Division Bench, which starts at the first page of volume 2, 145. This is the judgment dated 10th July 2025. Reads out everything. Here, my lord, the rules for challenge and all these things. Kindly comes to 167, running page, paragraph 31.
Yes.
In deciding the toll claim made on behalf of the tainted candidates, we may refer paragraph 363 such and such of the judgment. It is being quoted. 4 is persons who had appointed outside panel. It is being quoted. I will not repeat. Paragraph 32. Para 3634 has classified 3 categories of candidates who can be described as tainted candidates. So these are the 3 categories which can be described as tainted candidates. Our division bench says this is binding as of today. No challenge has been thrown to this. There is no interference. Number 1, persons who have been tainted outside the panel. We are not outside the panel. Number 2, persons tainted after expiry of the panel. We are not after expiry of the panel because expiry panel is paragraph 31. Persons who have submitted blank OMR sheets to obtain appointment. We have not, my lord,
You fall within which category?
nothing. None of this.
What is the illegality for which you are
My name should not have been included. That is my contention. Since I am not falling within this 1, 2, 3 paragraph, my name has been erroneously included.
and
My name is, we do not fall within this thicker. This is the short point that I wanted to agitate it before Lordship. And yesterday when your Lordship was directing, I just wanted to point it out to your Lordships that this figure, which was being conversed before your Lordship, would also include persons who have not been appointed. These are the 2 short points, my lord. That is why I wanted, my lord, your Lordship may kindly hears me, and thereafter, my lord, in this list, the names of another list is there.
the list?
My
Where
lord?
is the list?
Impugned list. Impugned list is annexed, page 185 onwards. Entire list is there, ending at 3512. Now, কি করে 3512 টা arrive করেছে দেখো। They have included the entire category. That's my very short point, Pala, that I want.
Entire category means?
Entire, my lord, this figure, my lord. OMR mismatch category. This OMR mismatch category.
Yes. So OMR mismatch will certainly come.
My contention is that the division bench has held that there will be 3 categories of tainted candidates. In that 3 categories, OMR mismatch has not been interpreted. The division bench has interpreted paragraph 363.
Sir, the Supreme Court has affirmed the order of the division bench.
Yes. And thereafter, the division
Thereafter,
bench.
the court is not concerned because day before yesterday or a few days back, Supreme Court has
I have
mentioned
seen that.
to follow only Boishakhi passed by the Honorable Supreme Court and nothing else.
After that, nowhere, not in the Supreme Court, not in the division
After
bench,
that,
there is nothing which shows who are the tainted categories.
the court will
It is
not.
only left to interpretation of the court.
The court has specifically made it clear, the last day's order,
Like order
that the order of Boishakhi passed by the Supreme Court should be the only consideration, nothing else.
Yes.
Why will the court look into all
Because
these things?
in Boishakhi, it has not been specified who are the
It
tainted.
has been.
Paragraph
It has
45
been
is the tainted. Then paragraph 45 upholds 363.
Yes.
That is, and
So that
363 is being interpreted.
How can that interpretation be looked into because the Supreme Court is there?
Then kindly see 363. 363 doesn't include
Show
OMR
me
mismatch.
that last
Yes,
week's
pardon.
order.
So if your lordship reads 363,
I cannot.
363 itself, it doesn't include OMR mismatch.
Sir, the Supreme Court on date is 26th of November, right? Clearly mentions that the High Court shall examine the matters influenced by any of the observations or merit made by this court in the orders passed after the decision in
Passed by this
Boishakhi.
court. Passed by this
Right.
court means Supreme Court was meaning to the order dated 17th March 2025. March naki April, 17th April. By which, my lord, this honorable court directed that the teachers would only continue.
the High
And the
Court shall
non-teachers will not continue.
also be mindful of the fact that the untainted candidates
Yes,
were
yes.
allowed to sit such and such,
No one should slip in.
and no one should slip
No
in.
one should slip in. I am saying so.
See,
There has to be a specification. No one should slip in.
the High Court shall
Paragraph
ensure
363 itself.
the tainted candidates are permitted. Please come.
Yes. 900, see,
The
paragraph
petitioner is-
363, kindly, my lord.
The-
Paragraph 360 doesn't include women mismatch. This paragraph 363.
Do one thing. You file the deficit court fees first. Please come. The instant writ petition has been filed by 475 candidates by
95.
depositing only one court fees. Stop.
490,
Leave is granted 495.
495, page 85.
495 candidates. The leave is granted to the advocate on record of the petitioner to submit the deficit court fees in course of the day, tomorrow, by course of tomorrow. Stop.
Tomorrow is also very difficult. 200
of the week.
230 into 400 হিসেবটা কোন?
200, not 230, it's 200. 200
Plus-
to 495,
Yes.
494.
Quite big.
So what? So
I have to manage. This has to be. I will do it.
how many candidates have come forward?
Yes.
By না tomorrow পাচ্ছে না, দুদিন দিয়ে দিন আরো, আজকে 2 তারিখ, 3 তারিখ, 4 তারিখ, 4th,
Yes.
4th, ঠিক আছে? Release the matter on 8th December.
Well, tomorrow is the last date, my lord. Tomorrow, 5th.
5th is the last date. 5th I'll fix it. 4th, by 4th you pay. We'll list it on 5th. The petitioners' names appear in the list of tainted candidates published by the West Bengal Central School Service Commission. Stop. They challenge the list and submit that their names have been wrongly included in the said list.
Oh, it has been extended
Till
8th.
8th. You want the matter to be posted on the 8th or the 5th?
6th.
6th Saturday.
Oh, আচ্ছা। Then my lord, in the 8th. 5 তারিখই থাক, দেখা যাবে।
5th এই থাকুক,
হ্যাঁ, থাক।
ঠিক আছে? In this said list. Stop.
That is aging.
What is the commission stand?
Well, then I would like to just place this order of this court, this honorable court, passed on 2nd September 2025. Would my lord kindly have a
You say how the names came in. It is from the CBI's list. It has come.
Everything from CBS.
Fine.
I'll also
Fine.
place
Marks they
CBS.
obtained was not matching with the marks scanned by CBI.
Yes, according to the commission,
Only one
list has been
paragraph of the
published
CBI
relying upon the data forwarded by the CBI. ঠিক আছে? Whether the list was properly prepared or not will be decided on the next occasion. Relist 5th. Come back. Yes.
Well, I'll be relying upon the affidavit of CBI also.
14?
Which is Delhi. Wait.
8. Yes. Who is your other side? 2023 matter? Yes, what is it?
The family pensions in respect of the unmarried daughter. Ultimately, the application was forwarded to the DI. DI has been rejected, all of order has been complied with, but due to the pendency of this writ petition, she is not given. Now, in the case of Sobita's Rai's judgment is applicable to this case, whereas the
Is it a pre-81 case?
Pre-81 unmarried daughter, 1968 married, the father died. Thereafter, pension payment order issued in favor of the mother. Mother died, and thereafter made an applications for granting family pension.
Yes, what is the stand of the
Malat,
state?
Director of Pension Malat returned back the file in 2024 on Malat, observing that Malat, your lordship knows 539 is the guiding factor for Malat pre-81 pension scheme. There is no
Shobita Roy is there.
Yes,
Please
yes.
make
Malat,
submission
I
on
am
that.
submitting Malat. They did not consider Malat, paragraph 19 of the Shobita Roy.
Please come.
Only thing Malat, DI instruction is that Malat school is required to submit document. This is the Malat.
Did the DI seek for documents from the
Yes,
school?
yes, twice, not one.
All right,
Twice.
not forwarded.
Not forwarded.
Please give.
Din. Twice.
The petitioner is the unmarried daughter of a deceased school teacher who was covered by the DCRB, who died prior to
1960.
the promulgation of the DCRB scheme, 1981. Stop. The petitioner relies on the judgment delivered by the special bench of this court on 20th June 2023 in the matter of Shobita Roy, State of West Bengal and others versus Shobita Roy in MAT 608 of 2021, IA Can 2 of 2021, page 24. Stop. The court specifically held that the benefit of family pension can be extended to unmarried daughter of an employee who died prior to coming into force of the DCRB scheme, 1981. When did the employee die?
1968.
1968 he died?
Yes.
আচ্ছা ঠিক আছে learned advocate representing the the state respondents relies upon the communication forwarded by the
District Nurses.
not communication, instruction forwarded by the district inspector of schools, secondary education, Bankura, where from it appears that the headmaster of the school was asked for submission of all necessary documents for family pension in favor of the petitioner. Today, office memo number 43/S dated 6th January 2023. Stop. Despite reminder granted to the school, the documents as sought for were not forwarded. Stop. According to the DI, as soon as the papers are submitted by the school authority, pension paper of the petitioner will be forwarded to the Joint Director of Accounts, Bankura, for vetting. Stop. Paragraph. Photocopy of the communications made by the District Inspector of Schools to the headmaster of the concerned school has been annexed with the instruction forwarded by the DI. Stop. As the right of the petitioner to receive pension has already been settled by the court, accordingly, the authority ought to take prompt necessary steps for finalizing and thereafter disbursing family pension in favor of the petitioner. Stop. As it appears that the school is not responding to the various communications made by the DI. Accordingly, the DI is directed to make necessary arrangement for collection of the required papers from the school authority. Stop. If the papers of the father of the petitioner who expired way back
I think my mother was getting
on 19 September 1968 কি বললাম right is not readily available, comma, then the papers relating to the family pension received by the mother of the petitioner, Bokul Rokhit, who expired on 20th May 2020, may be looked into for the purpose of preparation of the family pension file of the petitioner. Stop. In any event, the documents meant for finalizing the family pension of the petitioner shall be made ready positively within a period of 8 weeks from the date of communication of this order. Stop. The authority, the DI shall ensure that all papers are forwarded to the DPPG for issuance of the PPO in favor of the petitioner. Stop. All the authorities shall ensure that family pension is released in favor of the petitioner positively by 31st of March 2026. The writ petition stands disposed of.
For the petition in this matter is regarding whether there will be rotation in cooking mid-day meal or there will be one single self-help group will cook. Now, there is a coordinated bench judgments, including your lordship's judgment, where lordship has held that no, there is no rotation system is permissible because the rotation system has been withdrawn. May I just draw attention of few pages to your lordship? Kindly come to page 27 for once.
What is the stand of the state?
My lord, I'm, my lord, submitting, my lord, one government memo, my lord, which enumerates 1412 to 2018,
Have a copy.
which enumerates, my lord, that the duty has been casted, my lord, upon the managing committee of the school. My lord, kindly turn to page 8 of the memo. Duties and responsibilities of the VEC and MC, means managing committee and school level committee. If your lordship got it, my lord, the VEC and MC monitor the MDM program in the school in their jurisdiction. This committee ensures that the participation of the parents and the community in this program, they will engage the self-help group following the norms prescribed. They will also ensure that one of the members countersigns the monthly statement bill to be submitted to the BDO for payment. So the state government role is only to monitor, for not to engage the self-help group.
How are you monitoring if there is a rivalry between two self-help groups? What will the school do?
It is absolutely, I am submitting on instruction, it is the absolutely prerogative of the management of the school, managing committee of the school, to decide over it. So, the government has no role to play.
What are you supervising?
Supervising whether the meal is actual or not. It is also enumerates the power and duties of the BDOs, district magistrates, and everybody
Yes.
involved in the scheme.
And
Duties,
if there is a fight,
my lord,
then none of the children will get food.
the school authority has the self prerogative. Managing committee of the school has self discretion to decide the issue. Government cannot, my lord, take
But they are responsible.
any participation, my lord, into it, or
Possible.
they don't have any role to play in it, my lord. So for the all these students are getting, my lord, benefit of the same, my lord, it is only look out of them. But if the two persons are quarreling between them, my lord, so my lord, government has no role to play.
Government has
No, my lord.
may I just show to your lordship?
As
Yes,
per the, my
yes.
lord, said
No,
notification.
this is a scheme. I have gone through this scheme. There is another scheme also I have gone
Please
through.
show.
Yes, my lord, this scheme, there is nothing which speaks of this. This is just a general guideline which says.
Please show what
Ye-
is the scheme that you
No,
told
I'm
that-
showing the documents, my lord. My lord, kindly come to page 32 for once. First, my lord, page 27. As my learned friend has rightly stated that it is for the school to engage. Well,
Yes.
kindly see page 27. That the school gives certifies that I was engaged since 2008 and I cooked meal up to September 2023, but subsequently other groups came and put padlock and cooking was disrupted. Now, my lord, kindly come to the next page. It is the order of 2nd of June 2009, where the DM writes, in continuation of our memo number such noted above, this is to inform you that the cooking of midday meal has not yet started in many schools under your block. In order in order to run the midday meal immediately, we have no other option but to start the midday meal immediately with the existing SHGs, that is self-help groups, who are already engaged for the purpose. You are now requested to start the midday meal within 3 days with the help of existing self-help groups and submit a report to the undersigned. So we were existing in 2008. This is 2009. Since we were existing, we are continued. Now, my lord, kindly come to page number 31, where the BDO Suomoto introduced one rotation system. Kindly see, my lord, it says এত দ্বারা জানানো হইতেছে যে there is no official notification. That was just a paper that says that you have to monitoring committee পুরনো দলের সহিত নতুন দলগুলিকে রন্ধনের অনুমতি প্রদান করা হইবে, which created the problem. Previously it was not there, which created the problem. Now, my lord, this letter was withdrawn. Kindly take page 32, the next page. The BDO himself withdraws this letter on 26th of November 2015 has notified that the previous order issued with this office memo number such and such regarding an arrangement of cooled midday meal in education institution is hereby withdrawn, and any action taken with reference to the above said order is declared null and void. Midday program in education institution should have been in operation as usual as per existing government guideline. All concerns are accordingly. Now, my lord, kindly these
Is
two.
the school a party?
Yes, my lord, these two notifications has been considered by my lord Justice Chakraborty and passed the order. My lord, kindly see
It has
the
been
order I
withdrawn,
have.
my lord, since he has no authority. My
No,
lord.
no. That is why it has been considered. My lord, this kindly take the stand of the state in Justice Chakraborty's order. It has been recorded.
Serve the school once.
Very well.
Please
Sir,
come.
may I just place once?
The
It has been considered already.
What matter relates to
Your lordship's order is there.
engagement of self-help group for running the midday meal scheme in a school.
Yes.
Stop. The representation of the school will be required for the purpose of effective adjudication of the instant list. Stop. Let notice be served upon the respondent number 5. Indicating that the matter will appear in the list on 7th January 2026. Stop. Let a copy of the notice be also served upon the officer in charge, Halda Police Station, for onward transmission to the school, communicating the order of the court.
Yes.
Stop. In the event the school is not represented, then ex parte order will be passed.
There is only one difficulty. I don't know
Take this back.
whether the present school is in aligning with the present cooks self-help groups. That I do not know. I'm only.
You give notice.
I will. I'm only restricted to the notifications and your lordship's order, which has already
Next.
been passed.
Deeply
Grateful
obliged.
to your lordship. Obliged to your lordship.
Item 10, your lordship, I'm appearing for secondary board. My lord, I'm praying for an accommodation of this day because my lord, I have the brief I have left back, your lordship. Your lordship directed to file a report, my lord. The report is ready, but somehow the brief has not come to. My lord, petitioner
And
was here.
appears-
No, my lord, petitioner was here.
In this matter, Mr. Sudipta Manda
Yes,
appearing
he
for the
was here.
petitioner.
Where is he?
He is in code number 42, my lord.
My lord, he was here.
Going to make submission.
My lord, I am paying for Passover, my lord.
Passover.
My lord, kindly make it not today.
Not today.
Lordship.
I appear for the petitioner, my lord. When on last occasion, your lordship passes an order, my lord, directing the respondent to file a report, my lord. The matter relates to my lord house rent allowances, and they rejected my prayer, my lord. Kindly see page 27. They have rejected my prayer on the basis of a memo. The impugned order is at page 27.
Yes.
Now, they have rejected my prayer on the basis of a memo, my lord. I have annexed. My lord, next page, page 28.
GO 955.
My lord. My lord, the GO is absolutely, my lord, saying in favor of petitioner, my lord. There is no any words, my lord, against me. And that is why, my lord, your lordship directed them to file report, my lord.
Yes, please report.
Yes.
My lord,
My lord, I have taken instruction from commissioner as well as DI, because in the earlier order, my lord had directed, because the department is the appropriate authority, commissioner to be, my lord, consulted for making the clarification. But in the order, my lord, DI itself is itself there, my lord, but commissioner has been directed. My lord, I have taken instruction from commissioner as well as DI.
Give a copy to her.
Yes,
so
I
that
have
she
I'm given.
gets to know.
my lord,
Din.
my lord, again, my lord, they have rejected my prayer on the same, on the basis of same memo, my lord.
But has any
And-
ground been disclosed?
Just same
Yes.
thing, my lord.
What is the ground?
5, clause 5.
Clause 5, page
Actually.
29.
Clause 5.
Yes, my lord.
The
Yes,
director of school education with his view forward the same to the school education department.
No, my lord, clause 5.
Of my petition, writ petition.
Petition, that is page 29.
Page 20.
Page 29 of the Malot GO has been annexed is page 28, and relevant page is page 29, clause 5.
Read out.
Malot, then the director of school education West Bengal with his views forward to the same to the school education department government of West Bengal for consideration of issuance of order in respect of full HRA. Drawal of such full HRA shall be effected from the first day for the next month after issue of this memorandum in this respect of the incumbent.
What does this mean?
My lord, this memorandum is there. What the memorandum purports, that memorandum is an order favoring HRA in favor of the petitioner. Memorandum that they are trying to interpret, and as they have decided in the year 2024, and by that time, my lord, the entitlement 2070-2090, the entitlement is there, but they have actually decided 2024. And if by this, my lord, clause 5 will be, my lord, taken note of, then it will be, my lord, from the next date, as they are decided in the 2024, then that will be in the next month. That's why they have taken the point that area HRA is not, my lord, acceptable by this within this purview of this memorandum. But I think that this is sustainable, because claim has been contemporaneously raised by the petitioner. If they are deciding in 2024, my lord, what can be?
It is their fault.
Yeah. I'm very clear.
Yes, please come. The petitioner's authority relying upon memo number 955, page 28. এটা লিখে নেবেন তো ও এটা লেখাই আছে
Notification.
এটা লেখাই আছে Stop. It appears that the petitioner raised her claim for house rent allowance on regular basis as and when the same fell due, but the authority, for reasons best known, kept the claim of the petitioner pending. Stop. The spouse of the petitioner is employed is not employed with the state government. Stop. The the judgment passed by this honorable court in the matter of, give me that Moushumi Bishwash petition. अच्छा, आपने लिखे नहीं? Court on such and such date in such and such, in the matter of such and such, categorically held that the teachers of the non-government schools slash sponsored schools slash aided schools will receive HRA if their spouse works with some other organization but not the state government. Stop. Next. In view of the above, the rejection of the petitioner's prayer for grant of full HRA cannot be held to be a valid one. Stop. The same stands dismissed. Stop. The district inspector of schools, which place?
That is Barakpur.
Secondary Education, Barakpur, North 24 Parganas, is directed to process the request of the petitioner for claim of the petitioner for grant of full house rent allowance and ensure that the same is paid to the petitioner positively by 31st March 2026. Stop. As the petitioner would be paid her legitimate due at a delayed point of time, accordingly, she will be paid interest on account of such delayed payment at the rate of 5% per annum on the due amount calculated on and from the due date till the date of actual payment. The impugned order of rejection dated
25th January
2024 is set aside. The writ petition stands disposed of. Instructions, due to instruction আছে, be written with the records.
Moushumi, WK 1389, Moushumi, later.
I'm grateful.
Before my line of starts, my lord, there is an impediment on my part. My lord, today morning I have been interested with this matter. My lord, I have not looked into the brief even, my lord.
DI was supposed to file a report
But I have
as to whether the petitioner's application dated such and such will fall within the 10% of the teacher's strength.
only seeking for 2 days accommodation, my lord. Only
Four times, my lord, the order was passed to file a
my
report.
lord, the
What
advocates perhaps not in the panel. my lord.
What I am praying for. My lord, I have last occasion I have handed over my lord, the staff pattern. Headmaster also signed in 2025. Your lordship it will find, my lord, the petitioner is a geography teacher. There are other 4 geography teachers. So single teachers is not a bar. Now the petitioner's application was rejected 10%. That is with 2021. 2025, my lord, there are 45 teachers. None of the teachers applied for transfer. My lord, your lordship allow me to submit a fresh application. If anybody have not applied, my lord, for transfer in 2025 or within 10% of the teachers, your lordship direct the school authority to forward my application.
The petitioner seeks transfer. Stop. Her earlier application seeking transfer stood rejected in the year 2021 on the ground that her application did not fall within the 10% of the teacher's strength eligible for transfer. Paragraph. It appears that it appears now. According to the petitioner, there are there is scope for consideration of the petitioner's application seeking transfer as, according to the petitioner, comma, none of the teachers have applied for transfer recently. Stop. Prayer has been made to permit the petitioner to file fresh application seeking transfer so that the same may be considered by the school authority. Stop paragraph. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to seek transfer by making application in a prescribed format. In the event such an application is made, comma, the same shall be considered by the school authority in accordance with the prevailing guidelines and rules. Stop. If the prayer of the petitioner for transfer is allowed by the head of the institution, comma, then steps shall be taken to forward the same to the concerned district inspector of schools for taking necessary consequential steps.
So you also kindly observe that if it is not within the 10%,
The
or single teachers, then forward.
School shall take steps in the matter within a period of 8 weeks from the date of receipt of the application from the petitioner. And if allowed, comma, forward the same to the district inspector of schools within a further period of 8 weeks thereafter.
No, you'll also kindly observe that if it is not.
Yes.
My application, my lord.
I'm for the commission.
My lord, kindly come to the page 15, my lord, straight away. My lord, actually, I was recommended as an assistant teacher. My lord, thereafter, next page, page 16. My lord, school authority has given me the appointment letter and to instruct me within 30 days we will join. My lord, thereafter, one reminder, 15th January 2025, that was also issued by the.
What is the issue pending before the division bench? Submission was?
Yes.
Rajiv Brahman.
Shukumar Singh?
Sukumar Singh.
Yes.
Yes.
My lord, kindly come to the page 4 of the that judgment, my lord.
डिसमिस को लोग अलग अलग क्लैरिफिकेशन दिए चाहिए थे extension of recommendation
Attendant.
Do you fall in the same category?
No, my lord. Actual, this is for appearance of the counseling.
Yes.
Actual, I was recommended appointment letter was issued.
So it's different.
My lord, actual, this is not the same matter, my lord. Actual, considering the situation and present situation of the school, My lord, actual school service commission may be considered. If your lordship kindly direct, I have communicated the representation. Is considered actual 3 months.
Listen, your recommendation expired 1 year back.
My lord, kindly see the page number 6.
1 minute. What is the stand of the commission?
My lord, firstly, what needs to be checked is whether the candidate was a tainted candidate or not.
You have not checked.
No, I have not, but the prayer is literally an admission of the fact. Kindly see the prayer at page 8. It is continuing on page 9.
Yes.
He says that
Innocent victim of systemic corruption.
yes.
Is your name there in the tainted list?
No.
Sure.
Yes, my
And kindly see paragraph B also.
My lord, actual, I was joined in the lab assistant earlier proceedings. My lord, that was gone.
Yes,
That is was?
That was gone, my lord, by the view of the Honorable Supreme.
A 2016 recruitment process.
My lord, yes. Thereafter, my lord, I have already been appeared in that time. SLST 16 has come, and I have appeared on that proceedings. On that SLST 16.
In the 16 recruitment process,
Yes, my lord.
does your name
Yes.
feature in the list of tainted candidates?
No, ma'am. No.
Check up.
My lord. Yes.
If his name is there, from
Then,
here and
yes.
out.
Yes.
Yes.
And if his name is not there, does the vacancy still remain?
No, that I will have to check because
You have to
possibly
check.
there will not be any vacancy also, and that part I will be opposing. So even if there is a vacancy, I will be opposing. He will
Yes.
not. He cannot be entertained at this stage. Our panel has expired in the meantime, and he
Expired means expired long back.
no.
What in the meantime?
Huh?
After primary 25 September.
25th September 2025 it expired. He was called in the first phase of counseling. He apparently has not joined.
First phase of counseling when?
Yes, that was
15 minor 2024. 19/11/2024. Page 15, my lord.
yes.
See, the Supreme Court passed order in March 2025.
Yes. That is why after losing their jobs, now they are all trying to come into the upper primary selection process, which at that point of time they thought was not necessary. They did not visualize that maybe the entire selection process will be set aside. Though the division bench had already set the entire selection process aside, but they were hoping Supreme Court will give them something.
19th, no.
But that order did not.
I'm just trying to understand. That means this candidate never joined in terms of the 2016 recruitment process. He did join.
No, he joined and lost his job.
That is in 2024-25 when
yes,
the order
that
is
was the
passed.
2016 selection process.
Yes.
It ultimately, the entire process got set aside by the
Right, then
judgment
where
on 3rd April 2025.
Where does he want to be repatriated?
Now he had also applied for upper primary.
All right.
He was there as a group D, lab attendant group D. Now that
So
he
he
has
wants
lost
to
his
go
job
back there.
and he did not
Pursue
think
with
it.
his claim this
Yes.
year.
In a similar matter, my lord has already dismissed one matter with regard to teachers. He is a group D. Let us come back on the next date with the instruction and I'll also bring that order.
Please come.
Might not be a representative.
The order dated 25th of November 2025 passed by the Honorable Division Bench in MAT 1477 of 25 with IA Can 1 of 2025. West Bengal Central School Service Commission and another versus Shukumar Singho and others has been placed before this court. Stuff. Learned counsel representing the commission seeks time to revert with instruction as to whether the petitioner falls in the list of the tainted candidates published by the Commission. Stop. Instruction shall also be obtained as to whether there is any vacancy where the petitioner as to whether the vacancy in the school where the petitioner was recommended still exists or not. Stop. Information shall also be taken as to whether there are any other vacancies for accommodating the petitioner. In the event his prayer in the writ petition is allowed. Stop. Relist when 15th.
My lord will kindly record our submission that this Shukumar Singh does not apply in the case of the petitioner, and that in any event we are opposing his prayer for. Because my lord has given quite a positive order which
No, in
might
the
be
event,
read.
in the event his prayer is allowed. You never know. His prayer may be allowed, may not be allowed.
No, but the instructions, vacancies, other schools.
Let's see. Let's
Very
see. Because in respect of absentee candidates, the division bench is allowed.
Yes.
They were absent.
Under certain conditions, which my
Right.
learned friend will not
May
be
not.
able to fulfill.
May not.
I will.
At the first blush, it seems that it is not covering his case. Still, we'll see. I'm grateful, you love.
My lord, I am for the petition.
I am appearing for the commission, my lord.
My lord, the issue, my lord, last occasion, seek short for the time, whether petitioner's case is age relaxation should be allowed or not. My lord, petitioner age relaxation should allowed or not. Commission short for a time. Instruction, my lord, senior advocate, Mr. Kalyan Bandyopadhyay appearing. My lord,
why age relaxation?
My lord, age relaxation, petitioner has crossed, my lord, 40 years of age, which is, my lord, kindly turn page number just rule, my lord, once, page 25. Page 25 once, my lord, of my writ application. My lord, age relaxation, your lordship may, my lord, in respect of 910, my lord, age limit minimum 20 years, maximum 40 years. 11-12, my lord, similar. Nay, my lord,
Are you a fresh candidate?
No, my lord. I am job loser. In
You are a job loser.
I am, my lord. I have applied in respect of 910 and age relaxations given by the authority. But when I try to enter 11-12 level, my lord, the system is not permitted me. My lord, there is a window for necessary correction. Window is activated, my lord, up to my lord. Window is activated up to, my lord, 11th of August 2025. Subsequently, Honorable Supreme Court said no. Said there is age relaxation should given to the all the in all the both the selection process, which was come in 29th of August 2025. My lord, this is my case, my lord. And my lord, in this juncture, my lord, last occasion, commission sought for a time. If there is any, they seek a time that whether that it can be
Yes,
accepted or
Commissioner.
not.
Sir, we have filed a report, my lord.
You have?
Yes, we have. Yes.
Yes, my lord, report they have filed.
What does it say?
Lord, he has been negligent to fill up the form in the next part. One part he filled up correctly. Now he wants to edit his date of birth in the next 11-12 selection process, which he has not filled up. My lord will kindly see his prayer.
Yes, paragraph 4 and 5, my lord, they have stated, my lord, in their report.
The prayer is for correction of date of birth. There was an ample opportunity given, my lord. He did not correct it.
No, my lord, I have a little submission, my lord. Opportunity given up to August 14. My lord, subsequently, they cleared their stand in before the Honorable Supreme Court.
It has nothing to do with that, my lord, because every other person who got the opportunity to corrected it. Perhaps only he did not.
Age relaxation is given by the court's order, Honorable Supreme Court's order, but that I have annexed, my lord. And my lord, this point, my lord,
issue, my lord.
this
The
point,
issue
my
is
lord,
he has filled up the form negligently. Now he
yes,
wants
my
to
lord, this
correct
point,
it.
very good. My lord, this point I am relying a decision of
Where
Honorable
is your Date of birth mentioned.
Yes, date of birth, my lord, I have stated in my REIT application category.
It was
March
Yes, my lord, I have
1984.
categorically stated, my lord, kindly see page number 5, paragraph number 8. There's a page number 5. Lord, last 4-5 line. Even online system is not permitted to making any application for selection process in 11-12 level. Accordingly, the petitioner input his date of birth as 5th of March 1985 instead of 5th of March 1984 in 11-12. But I cannot enter in that, my lord, form. That is why, my lord, I gave an erroneous. It is an admitted fact. I am not disputing.
And this you did it in May or June when the advertisement
Yes, my
came.
lord. Yes.
Why are you
My lord,
coming
I am this point, my lord. This point is, my lord, kindly see this judgment once. Honorable Supreme Court pass. If that, I will take it. My lord, kindly see, my lord, similar issue is involved, my lord.
What is the issue?
Yes, yes. My lord, kindly see the issue. There is a discrepancy, my lord. Kindly see the, my lord, if your lordship kindly see the paragraph number 4. Kindly see similar issue, my lord. Erroneous date of birth. Erroneous, yes, my lord, erroneous date of birth in a selection process. Similarly, paragraph 4. If, my lord, honorable if there is an, it cannot be curtailed. Their right cannot be curtailed by this way. My lord, in 9-10 selection process, I have given a perfect input. There is no dispute. But by the time putting this question to myself, why wrong input has given the 11-12? But I was unable. My lord. That is why I put a wrong input and entered the selection. I have completed.
Because you may have 1, 2, 3, 4 cases. I over here have got hundreds of cases.
Yes.
This date of birth entry, you cannot make it properly. You are the only one that is coming up with this type of allegation. This type of allegation has not come.
Yes.
The caste could not be uploaded.
Yes, yes,
It's different. There are many things.
Yes.
But date of birth.
But when I tried to enter the actual date of birth, but system is not permitted me. I have.
How can it permit for others? System is not different for you.
My lord, Supreme Court's order come later, and that is
So
why, my
what?
lord, Supreme Court
So
their
you are
stand
relying
is.
upon Supreme Court's order.
My lord,
you are relying upon Supreme Court's
my lord,
order.
my lord,
In one place you could upload it, and the other place you could not.
My lord,
how can that be?
Yes, that is, my lord. Kindly
No.
kindly consider the situation, my lord. Kindly consider the situation.
Now the result interview list has been published.
No, my lord. Verification list has published. It is going on, my lord. In cutoff, my lord. My lord, my mark. I have secured low marks than cutoff marks.
Then
if 10
what
marks,
remains?
My lord, I have filed this REIT application much before.
Yes.
It has,
so what?
it has,
What are you waiting for? What do you expect from the court?
last occasion, first occasion, they sought for a report. They come up a report.
Yes,
Report has given. They have only agitated the wrong date of birth. They are only agitating the wrong date of birth.
Obviously, because that is the wrong date of birth.
I have stated in my application, it's REIT application itself that I could not. Last occasion, even commission sought for a.
Which one is correct? Your
1984.
9-10 one is correct.
9-10 correct.
You continue with the 9-10 selection process. 11-12.
So, my lord,
if it is gone, it is gone. Continue with one.
My lord,
see if you can manage.
My lord, kindly then.
Can I one make submission?
Led by Mr. Bandha.
Well, the problem is this, that he did not disclose his experience in the 11-12 form. 9-10 he has disclosed and he has got the benefits. 11-12 kindly come to page 40. He has not disclosed. Date of birth is not the criteria, but here the problem is this page 40. He did not disclose. And Lordship knows that there are a number of cases are coming before your Lordships also.
So you have not disclosed your experience.
Date
of birth, they say they ignored the date of birth.
Kindly record my submission and reliance of the judgment and my lord pass and reason order. I have no.
Because date of birth is not the issue.
My lord,
their issue is the experience.
Experience, my lord, ipso facto, if date of birth is corrected, well, ipso facto, I got the 10 marks.
No.
Ipso facto, I got the 10 marks. My lord, kindly visualize.
Your ipso facto is with
my
you.
lord, it is, my lord, admittedly.
Please come.
with the
The
leave of Mr.
petitioner
Bandyopadhyay, the
participated.
identical order টা দেখাবো তো?
Yes, yes.
Identical order of
Let me see.
Milord.
It is under challenge, my lord.
It might be, but here's the identical order which has not been set aside as of now.
Here was any representation we made?
Yes, yes.
20th September 2020, to update.
Much later, but my representation is the present case, much earlier representation in month of September. They have not considered the
Here
let
also
it be
September.
considered. No, say not September. At September, I mean they should consider it accordingly, my lord. Even Supreme Court held, my lord. It is I am covered by the decision of the apex court, my lord. If there is a wrong imputation, my right cannot be curtailed, my lord.
এটা থাকবে petitioner participated. এটা this will be a he and not a she. She alleges এটা ঠিক করবেন. A representation. What is the date of your representation?
Yes, yes. Representation, my lord, is
11th September 25.
48, my lord. 11th September 48.
All right, 11th September to update the details of her prior teaching experience. Achha, is vehemently opposed to submit the result of the written examination in respect of 9 and 10, 11, 12, all published. Here you filled up the teaching experience of 11, 12 or 9 and 10?
Yeah. Teaching
this
is for
case,
9,
9, 10 you
10
filled up.
perfect.
So she was unable to fill up the prior investment form. It change হবে, huh? She was unable to fill up in respect of classes 11 and 12. She was able to fill up her details classes 9 and 10. Result written examination declared.
Interview list published,
It has
but
been
it has not been.
submitted. The result of the written exam recruitment has been declared.
And my lord, kindly record my reliance. Kindly record. Otherwise, my lord, it will create some trouble into my client.
This
Yes.
I will not record specifically because date of issue is not the issue. The issue is your experience. Here there is nothing
Then, my lord,
to do with
date
your.
of kindly record the date of birth. There is no grievance against date of birth.
They say they have disclosed that there is no grievance.
Then
It is
my
only
kindly
your the prior teaching experience that has been highlighted.
That submission to be recorded, my lord.
Yes. Upon hearing the parties and presentation. Where is your 11th September representation? Please show me.
Yes. The representation is, my lord, page 48.
আচ্ছা 4 নম্বর প্যারাগ্রাফ লিখুন তো upon hearing the submission made on behalf of the parties and on perusal of the documents annexed to the writ petition, it appears that though the petitioner mentioned a wrong date of birth in her application meant for classes 11 and 12, comma, the commission does not harp upon the incorrect date of birth. HARP, H-A-R-P. The incorrect date of birth. Stop. The issue is the non-disclosure of the past teaching, not past, prior teaching experience. Stop. It appears that the commission provided several opportunities to edit/update the prior teaching experience, to update the details of the prior teaching experience. Stop. The petitioner, comma, for reasons best known, comma, missed the opportunity to do so. 5 will remain. Yes, dismissed. You can take this judgment back. It is not required. Next.
I beg to appear on behalf of the petition. Lord, Lordship, kindly consider the earlier order. There is a direction to submit a list.
Yes.
But
Close to the residence of the petitioner. Copy handed over to you. You've got.
Lord, I cannot join there.
None of the schools where there is vacancy you cannot join.
I cannot.
Then stay at home. Don't join.
Because, my lord,
The state has already filed 3 vacancies, my lord. Your lordships, my lord, on last occasion, my learned advocate.
1 minute. What is your submission?
My lord, my submission is that, my lord, initially, my lord, I have applied giving some list of schools. My lord, without, my lord, intimating anything that has been filled up. Subsequently, my lord, one, my lord, nearby school, there is a vacancy. There are 2 vacancies in a school. My lord, I have applied and I have indicated that, my lord, at page 41. My lord, that school, my lord, they have a earmark for second SLST. First SLST. Lord, what? Second SLST. Lord, what I am on, my lord, if, my lord, it can be interchanged. My lord, otherwise, my lord, I cannot join.
You are seeking transfer. You cannot have a vested right to join in a particular school.
I cannot argue.
Then, if the school vacancy is not there, what can be done?
But the vacancies are there.
No, but then that vacancy has been earmarked for a separate selection process to be filled up, isn't it? Commission, what is the way out?
My lord,
Just read from there.
Yes, my lord. My lord, the stand of the commission, my lord, when, my lord, considering the transfer application, my lord, verify the service code. Yes, my lord. The vacancy already reported it for direct recruitment shall not be filled up by transfer, my lord. The rules also provides for, my lord. So, my lord, if your lordships,
please come.
My lord, kindly direct the commission to give an opportunity of hearing and to give certain vacancy, my lord, since the petitioner had applied on medical ground, my lord.
The petitioner
But these vacancy, my lord, where, my lord, vacant
seeks transfer. Stop. A list of schools where vacancies are available nearby the residence, allegedly near the residence of the petitioner, has been handed over to the learned advocate for the petitioner. Stop. According to the petitioner, her medical condition will not permit her to join in any of these schools where vacancy has been shown. Stop. It has been submitted that there is vacancy in a different school but the said vacancy has been earmarked for being filled up in the recruitment process being conducted by the commission. Stop. Next paragraph. As it appears that the petitioner seeks transfer on medical ground, accordingly, the instant writ petition stands disposed of by directing the which commission? Secretary of the
Central School Service
Central School Service Commission to grant an opportunity to the petitioner for opportunity of hearing to the petitioner for production of documents in support of her ailment. Stop. The commission shall ensure that a suitable vacancy is identified where the petitioner may be posted on transfer. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed.
Item 16. I appear for the petitioner in this case. I do not know, my lord, whether report they have prepared or not, pursuant to your lordship's direction on 10th of November.
Commission.
My lord, the report is not ready, but in the meantime, in a similar matter, my lord had dismissed one writ petition, which went up in appeal, and the division bench. Oh yes, the division bench allowed, but specifically stated only those candidates who have applied when the portal was still open. So this,
What does the petitioner want?
he wants to.
Petitioners before your lordships are the diploma in special education educated qualified candidates. This is a qualification prescribed for the purpose of recruitment up to class 8, 5 to 8, upper primary level. Advertisement has been made by the School Service Commission that 5 to 10 we shall be recruiting only to the those candidates who are in degree in special education. We have said that we are the diploma holders, we have not the degree holders, therefore we are at least up to class 8 upper primary level, we are entitled to be recruited. That is the issue before your lordship's court, my lord, and that particular qualification has been accepted by the Rehabilitation Council that it is up to class 8, they are entitled to be appointed. We have the last date for filing the application was 24th of September. Since our applications were not, my lord, entertained, so we moved the writ petition before the Honorable High Court during the vacation, and it is the vacation bench. The Honorable Judge said that you file a report to that. No
Then
report
it
has
was
been
not
filed.
engaged. It was not. I don't know whether it was served.
It was
Whatever. Then what is to be done now?
My lord, let me file the affidavit since the direction is there. I have to file it.
But then if the date has expired.
Yes, 24th September.
Now, how can they be accommodated, especially when you are relying upon the division bench's order, which is
No,
in
division
favor?
bench order is in my favor because only those candidates who agitated their grievance prior to closure of the portal.
All right.
We agitated
That
our grievance.
specifically-
Our representations were there prior to closure of the portal. Our representation is at
You do
last
have
page of the
order of the
That is not to the commission. That is not to
14th of July 2025. The application was made to the authority.
No, not the commission. Kindly be specific. To Rehabilitation Council of India,
Which
New
page?
Delhi.
That is at page 271.
271.
Second volume.
What
Not-
will New Delhi do over here?
They are the authority, my lord, to regulate the recruitment process for those, my lord, special education candidates. And it has been held that jail stream also they are entitled to be appointed. We have been denied, so my lord, we have made the application there.
271?
271.
Last annexure.
Yes. 14th of July 2025. Application for inclusion of special education with
They're
graduation.
not saying equivalent. They want to be treated as equivalent.
Your application is for a different purpose altogether.
No, application for inclusion of D8
diploma in special education for graduate's degree as on eligible criteria for Department of School Education, Literacy Ministry, Government of India, published on 10th of June.
Right, but this is the commission must have floated a recruitment notice. This is
In
not mentioned.
September 2025.
Right, and
September.
that is not mentioned here. You could not have September 2025. The recommendation, the recruitment process is not mentioned in 271. And what will 271 do? After the recruitment notice was published, what is there to show that you applied?
No, I could not apply because I was not found eligible, according to the notification.
So your application is before there, the member secretary, let the member secretary consider.
But kindly come to this particular notification that was published, that is at page 25 on 9th of September 2025. There, my lord, the last date definitely, my lord, we say at page 26, 24th of September 2025. But the qualification, my lord, lordship will kindly come to, my lord, the qualification that has been prescribed for by the Board of Secondary Education and the School Service Commission's own notification that we are eligible for appointment. That qualification is already, my lord, mentioned. We are eligible for appointment. That has been, my lord, the notification is already there. And accordingly, my lord, we are applying.
You did not challenge the recruitment notification. That you have not included this degree. You have kept your degree level at such a level that you cannot participate.
That is exactly prayer has been made that we should be allowed to participate even offline for the purpose of up to class 8 we are eligible.
Recruitment, the recruitment process
has not been only notification. No, my lord, date has been fixed. No examination has been held. We are at a stage where only application stage. No date has been fixed for the holding the selection process. No date has yet been fixed.
How many court fees did you pay?
I paid only single court fee. In view of the division bench judgment of Justice Jayanto Vishwas,
Yes.
was considered
49 candidates coming for recruitment by paying only one court fees.
If your lordship so directs, I shall pay the court fees.
Yes, you pay the court fee and bring the division bench's order. Let us see what happens. The writ petition has been filed.
That has been admitted. Writ petition has been admitted at the motion stage. That point was not taken at the time when the matter was taken.
I never take this ground.
It appeared on that day.
Writ petition has been filed by 49 petitioners by depositing only one court fees. Stop. The petitioners seek permission to participate in a recruitment process, which a recruitment process. Stop. The last date for filing the application form expired in the month of September 2025. Stop. The instant writ petition has been filed on 14th October 2025. Stop. Whether the relief sought for by the petitioners can be allowed or not has to be decided. Stop. Learned advocate for the petitioners is directed to deposit the deficit court fees in respect of 48 petitioners by 5th December.
Give slightly more time, my lord, because
This Friday, today is 2nd.
Friday week.
Friday week,
Yes.
12th December. Release the matter for further consideration on 16th of December. Learned advocate, now the parties are directed to produce the division bench's order relied upon by them. Stop.
Well, I can keep it tomorrow. Lordship, I can, the judgment of Justice Jayanto Vishwas sitting with Justice Tapun Datta.
No. The special educator matter.
Oh, that judgment is not with me, my lord.
Yes, take the note.
A copy there.
The report as directed to be filed by the School Service Commission. Video order dated 16th October 2025. Shall be prepared and circulated prior to the adjourned date.
No date has been fixed as yet. My lordship can record that. Because otherwise it will
You chose time to file the court fees. I was keeping it this week, next week, so that it can be heard. You chose, so take your risk.
Oh my God.
17.
Lordship, then keep it on 6, my lord.
No, sorry, sir. Yes.
I am appearing for the School Service Commission.
Yes.
But whether or not the service rendered by the part-time teachers in government-sponsored and not the aided schools are to be reckoned for the purpose of not this experience weightage.
There was a direction for filing of a report.
They have filed a report.
Where is the copy? Is the copy here?
We have received a report.
Last question.
You filed it?
No.
No. Direction was passed on the last occasion. Where is the report? All right. Yes.
We have received a copy of the report. Not may I?
This is the exception. All right. What is?
Not the only ground taken not in is unless one not for the time being. May I hand up a copy?
No, it's all right. You place your case.
No, that's the point. Only point. Whether the part-time service can be reckoned for the purpose of this weightage. But the sole ground taken in the opposition is that one has to work in substantive post. And I just read that particular paragraph, paragraph 7. That's the stand of the state. It is evident that for availing marks for teaching experience, a candidate should have rendered service in a substantive teaching post at the secondary level in a government-aided or government-sponsored school, either as a permanent teacher or on a contractual basis. So, if one works on contractual basis, it's not standing in the way. But the only objection is one has to work against a substantive teaching post. Not all teaching posts in a government or government-aided or government-sponsored schools are substantive in nature. A substantive teaching post is a teaching post created in any government-sponsored or government-aided school with the prior approval of the competent authority, which in the instant case should be the government of West Bengal. So, a post which is created with the prior approval of the government is reckoned as a substantive teaching post, and any person who has rendered service against such post, be it on a regular basis or on a contractual basis, can count this past service as weightage. Now, apropos this, please come to these persons have been working not only against continuously, but they have also been allotted regular classes and examiners in the, and the other point is not every time the school has to renew its affiliation or the recognition, there has to be a sanctioned strength of teachers given. But these teachers are being cited as holders of posts against the sanctioned strength for the purpose of renewal of affiliation and recognition. But it has the identity of the teachers has to be disclosed subject-wise and subject-wise disclosure so as to conform to the requirement of sanctioned strength.
Is it your case that the sanctioned strength teachers are not there?
And we are rendering service in such posts. Therefore, what is a substantive post with the approval of the government? Suppose a person works for 25 years and the government does not sanction the post. Will that mean that the person is not working against a substantive vacant post? It depends on an executive decision. But not having utilized our services against the sanctioned posts of teachers in the subjects, the government is stopped from saying that these teachers who have rendered, say, part-time teaching services in the continuity are not to be counted, are not to be reckoned for the purpose of counting their past experience. More so when paragraph 7 of the report of the government says that even if they are acting contractually, they can be counted. So permanency is not a deterrent measure.
Determining factor.
Permanency is not essential. Even if I say not a post which is permanently created but contractually filled up. So the post is permanent the moment the school says that it is a sanction, the government approves it as a sanctioned strength of teachers. That's the sole point. And the definition does not make any difference as such.
All right. And do you like to rely upon any precedents in your favor?
Substantive post, I can rely on regularization. But that will not ipso facto directly apply in this case. Substantive post has not been defined as such in any law. The question is only with regard to the requirement of an establishment. But the moment the government approves that these posts are sanctioned for the purpose of renewal of recognition or affiliation, but it has to be reckoned as a substantive.
What have you annexed your exception to show
the
that
exception-
there are sanctioned vacancies and there is no teacher?
Only by way of an example, if your lordship will kindly come to page 18 of my supplementary affidavit.
Supplementary affidavit, yes.
Page 12, I'm sorry, page 12. I'm sorry, exception page 12. Not really, I'm sorry, not against. Please come to page 12. Please come to page 12 first.
Yes.
Of the exception. Not the type of institution, it's the fourth column from the top.
Co-education.
Yes, please see the heading, form for higher secondary subject permission request. Type of institution is co-ed, then renewal granted up to 30th of June 2028.
Yes.
Now please come down to the name of the teacher against the subject. He is a history teacher. And under the broad heading of subject paid for, he is a history teacher. Permission type is continuation. Category of teacher is part-timer. Then please consider this with page 20. Page 17. Page 17. I'm sorry, please come to page 17. Now, this is the school's portal revealing the subject teachers. Some of them are petitioners. This is the disclosure of the school.
Where is this Sushant Sarkar?
নাম দেখা একটা জায়গায় না ওখানটা আছে এখানে পোর্টালে দেখা So page 12 is the portal itself. There's the council's portal.
What is 17?
17 note is the list. Please come to page 16. This is for another teacher. To show that he has been appointed as an examiner.
No, that is different.
Yes.
That is different. What is page 17?
Page 17.
Total count, teacher designation, type, answer script evaluated.
This is not the teachers who have evaluated answer scripts. Please take page 16 and 17 together.
That means Sushant Sarkar did not evaluate answer scripts.
Please come to page 16. I'm not there. I can document enclose korichni. Please come to page 16 and 17. Oh, no, I'm sorry. Yes. Page 10, not yes, of course. Page 10 and 11.
Yes, examiner and scrutiner.
Yes.
He is there.
Yes.
No, but then what is page 17 and 18?
It's for another petitioner. Devashish Chatterjee, serial number 8 at page 17.
Same school?
No, it's a different school. Haridaspur High School.
How does all these parties come together in one writ petition? How do they join in? Where from do you get them? And they just club in one writ petition? Different candidate, different school, dates of appointment, different. In that case, there are so many writ petitions are not required to be filed. Only one writ petition throughout the state will be suffice.
Only one thing, that this is probably only for the purpose of a decision being taken as to whether part-time teachers as a whole can be reckoned or not. That's the sole point.
Yes.
I got your lordship's observation.
The issue as to whether the 2025 rules is proper or not. Let the entire state candidates come and file one writ petition. It's like this.
Different persons may have different causes of action to challenge, but not here. Not the single point is whether part-time teachers, in so far as the definition is concerned, I mean the concept is concerned, can be reckoned or not can claim this benefit.
And show me their advertisement and the rule where it is mentioned.
Not the rule has been annexed to the report.
Yes. You've annexed it with your writ petition also.
It's also in the writ petition, yes. Please come to not page 114.
Yeah, 114. I am there
At 124 and 125.
Right. Permanent and contractual. And you are part-time. All are part-timers.
Yes.
And their service is continuous.
Yes, Minor, it shows that continuing.
That is only in respect of one. You've got how many petitioners here?
But all these have been annexed to the writ petition.
Yes. Have you prepared a chart from where it can be ascertained your date of appointment, your date of continuation, and part-time you say? Anything of that sort, so that you place it in front and you get to see how they have worked.
Yes. Subject wise. And the schools.
Yes. So it becomes easy
at
for
a glance.
The commission also.
At a glance.
You can prepare, you should have prepared it.
Should have been done.
Otherwise, how will you argue they are part-timers? Nobody knows for how many days you work, maybe for 1 month or 2 months or 1 year or 2 years. Nobody knows.
All the documents have been annexed, not the initial letters and not the pay slips, not these have been annexed, but not for the cursory observation.
Who pays you?
From the school fund.
Right. That means nothing to do with the district inspector of schools, your service.
Not in so far as the state stand is concerned, I have shown to your lordship paragraph 7. Even a
can I show you one document, just one document? Can you see page?
Let me see your report. Page.
But can you see the page 28 of the writ petition? Can you see?
Yes, please.
So many candidates. See.
Yes, Raigram High School.
See, my lord, voluntary teacher.
What does this mean? Bona fide voluntary teacher? That means you are voluntarily giving service. The school is not willing to accept. You are going there on your own.
No.
What does this mean?
If this name features for the purpose of this has this expression voluntary teacher is there in GHC. No. Gorkha Hill Council. This matter has gone for months now.
So the headmaster of the school is saying that you are voluntarily teaching. The school does not want your service. You choose to serve the students.
If I can, all these documents would show that they have been, the recognition has been renewed on the strength of these persons.
No, but then
I will prepare a chart just to show for the length of service and the remuneration.
But if this is voluntary service, you go and serve. Who cares?
No, these are all part-time teachers. I shall show from the document itself. The portal, from the portal itself.
All right, come up. Let us see. Please come.
All these DIs and schools should be made party here.
Yes, lots.
They should be made party. Higher Secondary Council also be made party.
The instant writ petition has been filed by 18 petitioners by depositing only 1 court fees. The advocate on record of the petitioners is directed to deposit the deficit court fees by 12th December 2025. Stop. The petitioners, paragraph D, claim to be part-time teachers in government-sponsored / government-aided schools. Stop. They did you all fill up the application forms? You will not get the prior teaching experience, but then otherwise you can participate.
Yes, yes, we have.
The petitioners participated in the recruitment process for appointment of assistant teachers being conducted by the West Bengal Central School Service Commission. Stop. They seek marks on account of prior teaching experience. Stop. The issue to be decided in the instant writ petition is whether the part-time teachers of the government-aided / government-sponsored schools would be entitled to the marks meant for prior teaching experience in terms of the West Bengal School Service Commission bracket open selection for appointment to the posts of assistant teachers for upper primary level of classes. Third bracket, except work education and physical education, page 114. Third bracket close, comma, classes 9 and 10 and classes 11 and 12 rules, comma, 2025. Stop. The report filed by the commission and the exception thereto filed by the petitioners in court today be taken on record. Stop. The petitioners are directed to prepare a chart disclosing their dates of appointment, comma, the schools where they are serving, comma, and their tenure of service. Stop. Are the DIs parties?
No.
Who is going to satisfy whether you are working in a substantive post or not?
The district inspector of school lordship. All lordship are going to school.
That commissioner of school education can be.
No. Commissioner is not a lordship. District inspector of school, all lordships. School. Recognize. Commissioner is
Principal
not a
Secretary
lordship.
Education Department?
State has done this.
Lordship, I am in this matter, lordship.
The respective district inspector of schools shall be implemented as party respondents in the instant writ petition. Stop. The learned advocate representing the state respondents shall obtain necessary instruction from the respective DIs as to whether the petitioners are serving against substantive posts or not. Relist. How soon can you prepare the list? Chart.
2 days.
The 16th of December.
Lordship, in the meantime, lordship, give me the supply, the copy, lordship. In the meantime.
Copy? Which copy?
That is cited before his lordship, where the petitioner is working.
All right. You give the list to Mr. Boisho so that he can take instruction from the respective DIs.
Lordship.
Last second, next matter, already, they changed the admit card. CBS.
Which one? 17? 18. Please see. You got the marks? You were not present on the last occasion. No, he was also not present. Your junior was there. You got the marks? You are happy?
Only I surrendered the marks, old marks.
And they'll give you a new one. All right. Give me.
How many matter to get a English theory paper?
95.
Initially, how much it was?
72.
From 72, she got 95.
No, 75.
92 minus 95 my lord total.
Yes.
72 to 75.
72 to 73 marks you got extra. Please come. The updated mark statement comes certificate of the petitioner disclosing that the petitioner has been awarded 75 marks in English language and literature by the Central Board of Secondary Education. Handed over in court today, be retained with the records. Step. The grievance of the petitioner appears to have been redressed. Step. The petitioner is directed to return the old mark sheet, and the school is directed to hand over the petitioner the updated mark sheet at the earliest.
The board is directed to school to supply the new mark sheet.
This possibly is the original has been
Available on DigiLocker. The
Okay.
original one, my lord, it is with the board. Now
Oh.
they have to surrender the old mark sheet through school.
আচ্ছা তাহলে কি
Then
বললাম
board
ওটা?
will issue
The
revised.
petitioner is directed to surrender the old mark sheet to the school authority, who will thereafter forward the same to the board for obtaining the updated mark sheet.
And within a 1 month.
Stop. The updated mark sheet shall be handed over to the petitioner within a period of 8 weeks from the date of surrendering the old mark sheet before the school authority. How long will it take? 8 weeks is all right?
They will as expeditiously as possible. They will do.
At the earliest, but positively within a period of 8 weeks from the date of surrendering the old one. ঠিক আছে? Old mark sheet before the school
School
authority.
is not represented. My lord, my learned friend will communicate this order to the school as my lord. For
Learned advocate for the petitioner shall communicate this order to the school authority for necessary compliance. Disposed. Item. Court fees paid. All right, then it is একটু check করে নেবেন 17 please see Shailesh. All right. হ্যাঁ যদি দেওয়া হয় থাকে তাহলে ওটা লিখতে হবে।
This matter, I am appearing for the school. Respondent number 5. I have a preliminary objection, my lord, with regard to maintainability of this.
Yes. Yes. Let
What is the matter about?
Yes, my lord. The matter about is the suspension of the principal of a private school. But in the meantime, there is a development that apply before the deputy director of a school, government of West Bengal. They have taken a step after receiving the writ. Kindly see.
State is there?
State, yes, my lord. Mr. Chatterjee is there. Copy at the
Kingston Modern School.
Yes, my lord.
Does this bench have determination? Is it a
Secondary school, my lord.
secondary school?
Yes, my lord.
Model secondary school?
Yes, my lord. Secondary school.
Acha. There is a harassment of women.
Yes, also.
Rakhi Ganguly, she is a petitioner.
Yes, my lord.
Yes, what has happened?
That is the deputy director is the my lord respondent number.
No, what is your allegation that the petitioner was harassed?
Yes, harassed and
Sexually harassed?
also yes, my lord. 3 months salary has been held up.
Is
No suspension allows has been allowed.
harassment? What type of harassment? Sexual harassment?
Physical assault and by word.
Well, that is not the subject matter of writ petition. Kindly see the prayer. My learned friends.
ICC has taken steps. That means it must be sexual harassment.
My lord, this is, my lord, we have not received, my lord, as on date, I do not have any instruction. But this is, my lord, the subject matter of writ petition. Kindly see the prayer. This has nothing to do with this issue. seeking arrear salary and subsistence allowance. Now, my lord, why I said, my lord, this writ petition is not maintainable, my lord, she has been placed under suspension for two, my lord, allegations. First is huge financial irregularities. Second, my lord, maladministration. Now, my lord,
what is her designation?
She is the principal of the school, principal director. Now, my lord, she had shown, my lord, other students as, my lord, the students of this Kingston school, my lord, in order to obtain registration certificate from ICSE. This is the principal allegation. There are other financial allegations, my lord, but the question is,
who are you?
Service, my lord, I am the school, respondent number 5.
School represented by?
Represented by a society, my lord, respondent number 5.
Kingston Educational Institute,
yes, this
having
is a
its
society.
corporate office.
This is a society, my
President.
lord, under West Bengal Societies Registration Act. The service condition of the petitioners are governed by a non-statutory regulation. We are not, my lord, receive any aid from the government. Now, your lordship knows, my lord, this issue is no more a res integra, my lord.
How is the writ petition maintainable?
Yes, my lord. That is the question, my lord. That several decisions are there by the Honorable Supreme Court. My point is that if there is a violation of natural justice, and if it is a public function or duty of the institution, the mandamus can be invoked. And mainly, my lord, what is the alternate remedy? Now I ask my question. Alternate remedy is the civil court. But civil court has no contempt power or jurisdiction.
Contempt?
Yes.
Why are you going to contempt?
No, my lord, if the degree is passed, how the degree will be executed? That execution, 5 years, 7 years execution will be going on.
So civil
no
court
other
jurisdiction shall be stopped?
Yes, my lord. Let me submit, my lord, that no is a access to justice. That is 5-bench judgment, the Honorable Supreme Court, that the constitutional bench, my lord, that I am going to yes, access to justice. What is the remedy available or not? Yes, my lord. A citation is, my lord, the relevant
2016 8 SCC 509. Anita Kushawaha and Push-Up Sudan versus Push-Up Sudan.
There's so many matters, my lord, along with matters. That 5-bench judgment, I am relying that access to justice under the Article 21, it will come, invoke the Article 21, access to justice. And the access to justice, not mere in the procedural law or in the private and or public law. That access to justice is to be available, and it will, if the access to justice is not remedy so speedy, efficacious, then alternate remedy is not barred, because it will come under the Article 14 and 21 and also 39A.
What are the other articles that you want to rely upon? You've said so many.
14, that equal protection of law in the law of the land. First is that will invoke Article 40. And Article 39A also here discussed, because the Article 39A, the delivery of justice system, even in the economic constraint, should not be way. For that reason, Legal Aid Services Authority Act has been passed.
Listen, do not give this type of submission. You say how the writ petition is maintainable.
Yes, access to justice, my lord. That page 530 para.
You access to justice there in the civil court also. You've got access to justice.
It's not a speedy judgment.
Are you okay with this? They have already taken steps.
Yes, my lord.
You are okay?
Yes.
What is the use of proceeding with the writ petition?
They have taken my prayer. Kindly see.
You may have a lot of prayers.
Area salary has been held up.
Have a lot of prayers. The issue has been taken by the District Inspector of Schools.
Yes, my lord. After the service of the writ notice,
right,
that has been a step.
So
earlier
you
not.
Proceed with the DI?
Yes, my lord, they can. But my lord, area salary should be released.
You make your prayer before the DI? Why will this court entertain your writ petition?
Otherwise, DI previously has not been DI. I think that, my lord, it is my assumption that DI will not take such a step. If your lordship is pleased to direct DI,
No, no, no. Certainly not.
my lord, relief. I pray for relief, my lord. Access, speedy relief, and access to justice is
The
the
petitioner claims
paragraph
to be
36.
a teacher of a private institution. Stop. She is aggrieved as she has not been paid salary for the last 3 months.
Yes, my lord.
Stop. Prayer has been made to direct the district inspector of schools to take steps for releasing her salary. Stop. Paragraph.
The DI has not been made party.
Not it is not a government sponsored school. How will the DI entertain? I do not understand.
Well, the department also, your lordship will find.
I am surprised, my lord, to get this, my lord.
How the DI will entertain if the school is not affiliated to the state government, doesn't get any grant, no aid? How the DI gets in? I don't know.
I do not know, my lord.
Yes, but DI has issued this, my lord.
Absolutely not
The
understandable.
deputy director is a party, my lord.
Go to the deputy director and the director and to principal secretary, whoever you want to.
I pray just speedy justice.
It's just like instant coffee. You want. And
Litigant always,
the court acts in that manner.
no, that litigant always pray.
To
Not as physical effort.
no, no, this is a direct the state respondents kuru to take steps. ঠিক আছে? Learned advocate for the petitioner has placed before this court a communicating memo being number 705/G dated 26 November 2025 issued by the District Inspector of Schools Secondary Education Barasat, North 24 Parganas. Addressed to the Secretary and the Principal of Kingston Model School that an inquiry is scheduled to be held on 4th December 2025 in the school premises to inquire into the issue of harassment of women. Stop. Next. The school and the parties have been directed to cooperate with the inquiry team. Stop. Paragraph. It has been brought to the notice of the court that the school is run by a registered society. Stop. The same does not obtain any grant from the state government. Stop. The District Inspector of Schools Secondary Education has not been impleaded as party respondent in the instant writ petition. Stop. The respondents raise an issue with regard to the maintainability of the writ petition before the court. Stop. Paragraph. To allow the parties to revert with instruction, release the matter for further consideration on 5th January 2026. The issue of maintainability is left open to be decided at the time of on the next date.
My lord, just instead of 5th, 6th or 7th.
Why? What is the difference?
My inconvenience.
Your inconvenience.
The marriage ceremony in my home.
All right, enjoy the marriage. If the matter is taken up, your junior will be here. He can seek accommodation. All right.
Lordship, I am for the petitioner. I am led by Advocate Shubhusha Chatterjee. He is currently engaged in another court. Until he arrives, I will assist your Lordship in the matter. Lordship, the case in a nutshell was that the HRA overdrawn has been alleged against me, and on that reason, the ADR claim which I have filed have been withheld for a long time. Lordship, on last occasion when the matter was taken up, your Lordship had directed the District Inspector of School to come prepared with the written instructions.
Lordship, the written instruction is in this petition, in this case, your Lordship, they have relied
Give a
upon
copy to him.
they have relied upon a coordinate bench judgment passed by Lordship Shara. That order has been carried upon in appeal. The appeal is pending, though there is no stay. Now, in similar matters, my instruction is, your Lordship, the coordinate bench have passed certain orders giving relief to the petitioner, but that may depend upon the result of the appeal court order, your Lordship, is it is in MAT 102.
Please come. The District Inspector of Schools, Secondary Education, Howrah, has forwarded a report dated 27 November 2025, clearly disclosing that the spouse of the petitioner did not work in the government concerned, as per the documents annexed to the writ petition. Stop paragraph. The DI has mentioned that the relief of giving full benefit of house rent allowance has been allowed in terms of the order dated 16th March 2021, passed by a coordinate bench of this court. Only to the teachers who have obtained specific judicial orders. Stop. Paragraph. It has been brought to the notice of the court that an appeal being MAT 1023 of 2021 against the judgment dated 16th March 2021, passed by the court in WPA 1389 of 2018, is pending consideration. Stop. The order of the coordinate bench has not been stayed till date. Stop. Paragraph. In view of the above, the claim of the petitioner to receive full benefit of house rent allowance has to be allowed in favor of the petitioner. Stop. The respondent authorities are directed not to recover any alleged excess house rent received by the house rent allowance received by the petitioner. Stop. Paragraph. The The this order is being passed subject to any order being passed in the pending appeal being MAT 1023 of 2021. Stop. Is there an impugned communication? Order?
Yes, Your Lordship.
Which one?
Your Lordship, I made a representation to the authority.
For what?
Your Lordship, before filing the writ petition, Your Lordship, P4 and P5.
That means there is nothing to be set aside.
Your Lordship, yes, Your Lordship. Yes, sorry, Your Lordship, I got it.
The communication made by the Assistant Director
Your
of
Lordship, that is
Accounts,
P5, page number 53.
Secondary Education, Howrah, dated 24th December 2024, stands set aside. Disposed.
Grateful, Your Lord.
Review my appeal for this case.
Lord, Mr. Tonju Tiwari will appear on behalf of the petitioner, but we need some instruction. That's for reason we need some more instruction. That's for reason I am paying 1 week adjournment.
Commission was meant to come back with instructions.
Last part of the order.
Let me see.
80 to dot check with them.
What is it?
Well, these part-time teachers are asking for experience marks.
That means marks have been awarded to similarly placed candidates.
This is well, kindly turns to serial number 141. So they have
Page 9. Page 9. Page 9 of.
9. So they have taken the example of two candidates. One is
Bishwajit
Bishwajit Barik and one is Manoj Kumar Jana. Well, it's 141 is Bishwajit Barik. Current status says not in cutoff due to change of experience marks. Previous experience score 10, current experience score 0. So, for part-time teachers, we are
No,
not.
that means
allotting-
previously, did you allot 10 marks to the candidate?
Well, they had given the experience years in the application form. Thereby, so on that disclosure, we had to allot 10 marks. So once they came for verification, and when we checked the documents that he is a part-time teacher, we had to take away those 10 marks. So the commission is not allotting 10 marks to, even if previously given, it is being taken away.
What about Manoj Kumar Jana?
Manoj Kumar Jana, that is yet to be updated. So if he is found that he's a part-time teacher, then his marks will also be taken away.
The list of candidates found to be disqualified for interview and lecture demonstration after the verification phase, handed over by the learned advocate representing the commission in court today be taken on record. Stop. It appears that Bishwajit Barik, who the petitioner referred to, has not been awarded marks on account of teaching experience. Stop. The marks which was provided to him on his self-disclosure was found to be improper. Stop. The commission is yet to verify the credentials of Manoj Kumar Jana.
His verification is happening today.
Paragraph. To allow the commission to revert with instruction released next Tuesday, 9th.
Obliged to Lord.
Lord, in 21, my Lord, I am for the state respondents led by Mr. Boyce, who is in virtual mode, my Lord.
21, my lord, I am led by Mr. Ujjwal Rai in this matter. This matter, my lord, your lordship had granted us leave to file a supplementary affidavit.
Copy we served upon us.
Copy.
Yes.
Yes, sir. My lord, let me hand over a copy of that.
Yes, please. In that case, they will require time to come back.
My lord.
What is the matter?
My lord, the issue here is that the petitioner.
Cannot be asserted with the previous submitted. All right. What does it say that you submitted objection at the first stage?
I did not, my lord, because I have said that the affectation of my right, the cause of action arose only after I saw that a question which was perfectly within the syllabus, they have given marks, 3 questions which were within the syllabus. The commission has awarded marks to everybody who has attempted it or otherwise. But in my case, my grievance is that there is a question in series D which relates to B.R. Ambedkar's founding of the Independent Labour Party, which according to my case is that this question was out of syllabus. And for that, my lord, I had addressed a representation after 10 because I had no idea that the questions which were within syllabus, the commission would grant everybody same marks. Because of that, I suffered prejudice. And after that, I wrote an email to the commission stating that this question number 3, as regards B.R. Ambedkar's Labour Party, is out of syllabus. Now, my lord, I have also cited an example whereby after publication of the final answer key, my lord, Commission has issued a notification dated 10th November 2025, whereby marks has been accorded in respect of questions which were out of syllabus in geography. It's annexed to the supplementary affidavit. Yes, after the final answer key was published.
Was it? Copy extra nahi?
Sorry?
Would you like to come back with instruction? Please come.
I would like
Supplementary affidavit filed by the petitioner in court today is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the respondents in court today. Stop. To allow the respondents to revert with proper instruction, released on 16th of December.
It appears. Ask for question. Deeply obliged.
Lordship, I am obliged, Lordship.
22, I appear for that is regarding 10 marks to the teachers of DA getting students. Kindly have a look to the last order minute.
করতে হবে
Now, the case of the petitioner is that I am a teacher of a day getting school unapproved. I am discharging my duty for last 12 years. Now, your lordship is aware that in the DA getting schools, the appointment of the teachers are made by the school, approved by the DI, then only the DA component is released. Now here, I am asking for 10 marks. As well as kindly have a look to page 63. In the written examination,
how much did you secure? 51?
51 out of 60, 85%. Now, 10 marks will
take it to 61.
61. I'll be within the zone of consideration. I am against a Hindi medium school. This is not Bengali medium. So, my simple contention.
There are vacancies.
Yes. 27 vacancies are there in the Hindi medium.
How many candidates are contesting for this?
That the commission has the information, I don't have. But if your lordship kindly says simple contention, the approval is given by the DI for DA and the appointment and the board, West Bengal Board of Secondary Education, the board is the authority to approve the election of the managing committee. So, but the government has control over the school. It is not the case that the government has no control on the school. This is my case.
Yes.
Well, I'm on a simple point, that is the application form is missing.
Missing?
From the written petition. It is not annexed. If there is disclosure of past teaching experience, those 10 marks given, regardless of the fact whether it's a DA getting school or it is not a DA getting school or it is anything, my lord. So when the verification, at the stage of verification, when he comes and he shows that there is past teaching experience, we check the credentials. Now it's left for us to see whether we are going to give it or we are not going to give it. But in the application form, Millard knows it. That
where's the application form?
Well, I tell you, Lordship, well, I
Could
cannot
not fill up because
I
the
ca-
teacher
because of-
code was not
yeah,
there.
The teacher code was not provided.
And if the teacher code is not there, can you not fill in how many
No.
years service
I
you
cannot. But
have
the teacher
rendered?
code needs to be supplied by the school. And that is why, my lord, the last order was passed by the school. A copy has been served on my learned friend to seek instruction from the DI.
So he could not fill up the application form. And he admits that he could not fill it up because he doesn't have the teacher code.
We'll check the application. The application form we have.
I admit that I could not.
Yes, that is recorded in the earlier order also.
But on the last occasion, your lordship was pleased to direct me, my lord, to take instruction, my lord, whether, my lord, the school is a DA, my lord, he is the approved teacher or not, my lord.
So he says he is not an approved
Not
teacher.
approved teacher, my lord.
And is he working against any sanctioned vacant post?
He is not working against any sanction post.
একটু দেখবো
হ্যাঁ নিশ্চয়ই কেন
How is she teaching?
In a DA getting school, it is permitted. In a DA getting school, it is permitted.
So after this, can you, do you have any claim?
I cannot.
Well, I have just received instruction that teacher code is not mandatory. Many have filled without.
No, but then if you go on changing your stand, how will the candidates get to know whether it is mandatory, not mandatory? If there are fields, it has to be filled up. Then?
But for us to give the prior teaching experience marks, only thing is required is the prior teaching experience number of years to be disclosed.
Irrespective of the fact whether the candidate is teaching against a sanctioned post or not?
So when they disclose, we give it. Then during the verification, when we see that they are not against a sanctioned post, we take it away.
What does it mean? You give and take, it means nothing.
That is how the workings of the
No, that is not
rules
the
are.
proper way of functioning. The teachers, the candidates who are applying should know as to what exactly is your nature of functioning.
So then Malak kindly takes up the rules which they have annexed at page 28. Malak, this would be schedule 2, A2, then Malak B, prior teaching experience 10 marks. It is clearly stated here that at the secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post. Permanent or on
See, this argument has been made on a number of occasions. The court will not spend any more time. Please come. From the
And in a
report
substantive
forwarded by
post
the
as permanent or on contractual basis. So, my lord, if my appointment is on contractual basis also, if your lordship will sees my appointment letter,
such and such, dated such and such, it appears that the petitioner is not working against any sanctioned vacant post in the school. Stop. The requirement of the rule pursuant to which the selection process is being conducted requires teaching experience in a substantive post as permanent or on contractual basis.
Yes.
Stop. The District Inspector of Schools does not mention that the petitioner is working against any substantive post. Stop. Next. In view of the above, the prayer of the petitioner for awarding marks on account of prior teaching experience cannot be allowed. Stop. The writ petition fails and is hereby dismissed.
Well, may I only show to your lordship one page? Before
What will you show?
till this month I received salary from the school.
Yes, they admit it.
Yes, then substantial or contractual. But if I am on a contract basis post also, but for last 14 years I am discharging my duty. Kindly have a look to judge of petition.
No. Please, I'm not going to reopen. You try to see if the appeal court is in your favor or not.
Appeal?
Please try and see. There are matters where the appeal court is interfering and passing orders.
I'm here before your lordship. Kindly give me 1 minute time to satisfy.
Please call. Yes.
But it is not possible for every client to go up in appeal.
I understand very much. And keep an eye as to what happens to the rules because they are under challenge.
Very.
Yes. 22.
And for the statement.
Yes, please.
Lordship, this is a writ petition praying for a Lordship the pension of the unmarried daughters.
Yes.
Lordship, there are two daughters. One is the elder, I am the younger. This court directed the Lordship the elder daughter to be a party as an added respondent. I have added and also directed to file an affidavit exonerating her claim that if the Lordship the unmarried daughter's pension is disbursed, she has no objection. Also, I've received the copy of the affidavit. Now, Lordship, my claim, Lordship, this is admitted fact that unmarried daughter at present entitled to get the pension. Lordship, there is no dispute. Now, here is the dispute is what is the limit of income. Now, Lordship, my application has been rejected that and observing that my annual income is 60,000 per year.
Which page?
That is page 109.
All right.
Although, Lordship, I had disputed my income is not 60,000. Now, the government of West Bengal, Lordship, reliance upon the notification of the State Finance Department, issued a notification in 2023 that the income limit of the unmarried daughter from 3,500 per month to 9,000 it has been extended. And to that extent, an order has also been passed. Yes, this is secondary education, Lordship. They kindly come the last page and the order. In terms of the memo dated such and such, the Finance Department Pension Branch has raised the income ceiling for entitlement of the family pension of the state government employees and pensioners, respectively to rupees 9,000 only per month. As per the order dated 21st August 2023, such and such, the proposal for raising income ceiling of unmarried daughters only of teaching and non-teaching employees, pensioners of government, non-government aided education institution West Bengal from 3,500 to 9,000 only per month for entitlement of the family pension. After careful consideration of the matter, the governor has been pleased to decide the income ceiling of unmarried daughters only of teachers and non-teaching employees of the pensioners non-government aided education institution West Bengal be raised from 3,500 to 9,000 only per month for entitlement of family pension, and this will immediately effect from the date of issuance of order, and other terms and conditions shall remain the same. Now, Lordship, subsequently, the widow and Lordship, kindly come my notification of annexed in the that is page 117. The widow.
Well, this is of 2023.
Yes.
Right?
Yes.
Your rejection was prior to this.
Yes.
Right? So let them consider it afresh.
In terms of this.
Right?
My lord, one more thing, my lord. My lord, the other ground of rejection was the fact that there was an elder daughter,
No, that
elder sister,
come by way of
by way of an affidavit. Just two things, my lord. As per the rules, kindly comes to page 114, my lord, of the petition.
Yes.
First clarification against serial number 2. When the deceased government employee has more than one divorced widowed daughter, family pension shall be payable in order of the date of birth, and the younger of them will not be eligible for family pension unless the next above her became ineligible for grant of family pension. Thereafter, my lord, the next page again.
How does this help you?
I'm unmarried.
My lord, my lord, may I place the next page, my lord?
All right.
Next page, my lord, the last 3 lines of the penultimate paragraph.
All right.
Grant of family pension to unmarried, widowed, divorced daughters shall be payable according to their date of birth.
It's the same thing.
Yes, my lord. And if my lord sees the impugned order, which is at page 109, at page 110 it is written that one's eligibility can't be transferred to another. So they have followed those rules and they have said that this cannot be transferred. But my instructions are, my lord, that since the income ceiling has been raised to 9,000, if they submit the fresh income certificate and the legal age certificate, may I produce my instructions, my lord? My lord may see the second page.
Please come. The prayer of the petitioner for grant of family
May be considered,
pension
my lord.
in respect of widow,
Unmarried daughter.
unmarried daughter. Widow হবে না, unmarried daughter of a teacher of a secondary school,
Yes, teacher.
aided, government aided secondary school. কি দিয়ে শুরু করেছিলাম? Yes, was rejected by the district inspector of schools, relying on the memo being number 95 within bracket 80-SE, page 109, within bracket caps B, dated 13th April 2010. And also, as per GO number 432-F within bracket pen, dated 2nd July 2008. Stop. It has been brought to the notice of the court that the income ceiling of family pension has been raised by the government by memorandum being number 1613. Please copy. Dated 9th November 2023. Stuff. Next. The petitioner has an elder unmarried sister, right?
Unmarried daughter.
Unmarried sister.
Unmarried sister, who is eligible for receiving the family pension. Stuff. The said unmarried elder sister has disclosed her intention not to accept family pension. Stuff. She has also disclosed that she does not have any objection if the family pension is awarded in favor of her younger sister, who is otherwise eligible to receive the same. Stuff. Paragraph. The honored advocate representing the state respondents relies on the communication made by the District Inspector of Schools, Secondary Education, Hooghly, dated 4th September 2025. Has disclosed that the In the family income ceiling limit has been raised. Are you aware there is another memo, 2024 memo, School Education Department? You are relying upon 23 memo.
Yes, 24 memo I have also annexed,
Where?
117. That is in respect of divorce